Imagine living in a country where your most basic legal rights, how you marry, divorce, or inherit property, change entirely depending on your faith. In India, this is the daily reality. The country operates on a system of personal laws. Instead of a single civil code for everyone, there are separate religion-based rulebooks for Hindus, Muslims, Christians, and other communities. If you are Hindu, your civil life is governed by statutes like the Hindu Marriage Act. If you are Muslim, you follow Muslim personal law. These parallel systems separately dictate the exact terms of family disputes and inheritance. But in 2024, Uttarakhand took a definitive step. It became the first state since India's independence to completely throw out these separate rulebooks. In their place, Uttarakhand implemented a Uniform Civil Code, or UCC. This is a single, secular set of rules applied equally to every citizen within its borders, regardless of their religious identity. Uttarakhand's move has triggered a national chain reaction, with multiple other states now drafting their own versions. These legislative changes are poised to alter the legal standing of hundreds of millions of people regarding marriage, property, and family rights. Which brings up an immediate question. How can a single state government rewrite fundamental civil rights without getting approval from the national parliament? This diagram illustrates the answer. It's a constitutional mechanism called the concurrent list. This essentially means that powers regarding personal law are shared. Both the central government in New Delhi and the individual state governments have the legal authority to legislate on marriage, divorce, and succession. Because achieving a national consensus on religious matters has proven historically difficult, individual states are now using this shared power to act alone, bypassing the gridlock in the national parliament. The architects of India's constitution actually anticipated this debate 75 years ago. They included Article 44 in the Directive Principles, which officially instructs the state to eventually secure a uniform civil code for all citizens. For decades, the Supreme Court of India has repeatedly pulled the alarm on this dormant directive. In major cases involving maintenance rights and gender equality, the judiciary has urged its implementation to guarantee universal legal protections. By leaning on the concurrent list, what was once a stalled blueprint at the national level has become a highly active race among the states. We are already seeing a domino effect spread across the map. Following Uttarakhand, Assam and Gujarat have passed similar bills, while states like Maharashtra and Madhya Pradesh are aggressively planning their own codes. Reformers argue that a unified code is a prerequisite for secularism and gender equality. They specifically target the elimination of practices like polygamy, which currently vary depending on a citizen's religious rulebook. This shift creates deep friction within the social fabric. Many minority communities view their specific personal laws as essential to their group identity, interpreting a common secular code as a direct path toward cultural erosion. The intensity of this resistance is visible on the ground. For these groups, the erasure of faith-based statutes is not an administrative change, but an attack on the identity of the community itself. This tension is rooted in recent history. During previous legal reforms, such as the ban on triple talaq, the pushback illustrated how quickly debates over individual rights can become high-stakes conflicts over religious autonomy. This leaves policymakers in a difficult position. They are navigating a zero-sum debate, where every move toward universal legal equality is defended against by groups who see it as a strike against their cultural survival. There is also a major hidden risk to this state-led rollout strategy, one that lies right at the physical borders between the states themselves. This map highlights the problem. If individual states continue to pass their own unique versions of a civil code, India risks creating a confusing legal patchwork. A citizen's rights regarding divorce or inheritance could change the moment they drive across a state line. This fractured map is the gamble. These early state tests will either create an unmanageable mess of conflicting rules, or they will build the momentum necessary to force a single national law through Parliament. We are watching a significant test of India's federal design in real time. The push for a uniform civil code forces India to settle a long-standing debate whether a secular democracy functions best with identical rules for everyone or by protecting the legal distinctness of its diverse cultures.